Thank you, Honourable Member. As many, point of order. The Chair recognizes the Honourable Member for Marco City on the point of order.
I have the podium. Yeah. It's going to take a while. Mr. Speaker, I rise on a point of order really to speak to a matter that the Honourable Member for Foxhole spoke to. It's a constitutional matter, and insofar as it's a constitutional matter, it rises to the level that I believe we all in this House have the obligation to speak to and to clarify. And there's 2 points with the greatest respect, Mr. Speaker. One speaks to this matter of people being born in the Bahamas to parents of Haitian descent, upon deportation not being stateless. With the greatest respect, that's not accurate. The Constitutional Commission spoke to this matter, Mr. Speaker, in their report at paragraph 14.31. And in their speaking to it, they made the point that only first-generation people who are first-generation Haitians in this country, who are born to native-born Haitians in Haiti, have Haitian nationality and Haitian citizenship. Second, third, fourth, fifth, and beyond don't. They have no citizenship in Haiti. It's not my opinion. I'm just going to point to it in the Constitutional Commission's report, because I want to make sure we know what we're doing when we talk about deporting what I always refer to as undocumented Bahamians. I'm not talking about the issue of Haitian parents who were born in Haiti. I'm talking about the issue of any Haitians who were born in the Bahamas after the first generation. This is what the Constitutional Commission says, Mr. Speaker. Paragraph 14.31. The most significant issue under the Constitution is Article 7, which operates to reduce many people to a situation of effective statelessness, as the persons who are primarily affected are either unwilling or unable to avail themselves of the other nationality to which they're entitled. When you read that, that seems fairly innocuous until you see the note 49, and then you go to the back of the report and you look up note 49. And there it says this: the vast majority of persons affected by this provision are persons born in the Bahamas to Haitian parents. The Haitian Constitution provides for persons to acquire nationality through descent, but, and these are the operative words, only if either of their parents is native born and have never renounced their citizenship. The Haitian Constitution only provides citizenship for persons born out of Haiti where their parents themselves were born in Haiti. And that's why I say it's only first-generation Haitians in the Bahamas we're talking about, who will not become stateless if we deport them. It goes on to say this: thus, those persons born in the Bahamas to a native-born Haitian parent who has not renounced Haitian citizenship would be Haitian nationals during this period. But if their parents were not native-born or have renounced, they would effectively be stateless. It's important to clarify that in this House, because what we are talking about, and I've spoken to this in small measure, and I think for something as important as this, the greatest respect, this shouldn't be a policy decision. We should be in this House debating this, so we have the opportunity to properly consider the implications of what we're doing. But the point is made by the Constitutional Commission, and the point is made by a careful reading of the Haitian Constitution. Any Haitian national born in this country whose parent was not a native-born Haitian in Haiti would effectively be stateless if we deport them. That's one point. The second point, Mr. Speaker, is the constant reference we hear to Haitians having a right or an entitlement to apply. With the greatest respect, this has been misstated also, and has actually been misstated by the Constitutional Commission itself. And that's at paragraph 14.17. The Commission says this article, which relates to children born in the Bahamas, where neither parent is a Bahamian and entitles them to apply for a citizenship at the age of the 18, is the most problematic. They use that word entitle. They're essentially saying, when you look at the Constitution, and you'll see in a second it's Article 7 of the Constitution, persons born in the Bahamas are merely entitled to apply. The Constitution says no such thing. Article 7 of the Constitution actually says this: a person born in the Bahamas after 9th July 1973, neither of whose parents is a citizen of the Bahamas, shall be entitled, comma, upon making application on his attaining the age of 18 years or within 12 months thereafter, in such manner as may be prescribed, comma, to be registered as a citizen of the Bahamas. Not to apply, you know. Reading it without the parenthetical commas, it says this: a person born in the Bahamas after 9 July 1973, neither of whose parents is a citizen of the Bahamas, shall be entitled to be registered as a citizen of the Bahamas after 18 years, at 18 years of age. To be registered, not to apply, to be registered. And this is something that I feel extremely strongly about, because what we are talking about when we get past first-generation Haitians born in this country, we're talking about undocumented Bahamians, and we're talking about deporting them from this country, which at age 18, they are entitled to be registered as a citizen in. That's what we're talking about. So I make the first point again. That point that if we deport them, they will not become stateless, only applies if they are first-generation Haitians born in the Bahamas to parents who are native to Haiti. It does not apply to this problem we've been having for the last 40, 50 years, because many of them are not first-generation Haitians. They are the children of those, and the children of those, and the children of those. Second, third, fourth, fifth-generation Haitians who have fifth-generation people born in the Bahamas, two parents of ultimate Haitian ancestry who have no right to citizenship in Haiti and who under our Constitution are entitled to be registered at age 18. That's what we're talking about. And in the same way that I will defend with every ounce of my being the right of any other Bahamian citizen to all of their constitutional rights under our Constitution, I will also defend the rights of undocumented Bahamians who would be stateless by these actions under our Constitution. Thank you, Mr. Speaker.
Thank you, Honourable Member. Member for Foxhill, your response.
One of the interesting things about this is when you seek to answer, the goalpost gets moved. So fine, we're now dealing with the next generation. If you look at the policies of the Bahamas government with regard to this, it says that any time someone is actually stateless, the Bahamas fulfills its international obligations with regard to it. The international obligations, as I understand it, when someone is stateless, is that we have to provide a status for that individual. So the question of deporting someone who's stateless is in that position does not arise. And it appears to me that, that one is raising something which is not an issue. And all I'm saying is that if someone is actually stateless, the international obligations kick in Bahamian law. Now, the other thing I would say is this. There's a lot of debate back and forth about what the article that he read from the Constitution means about registered and apply, so on and so forth. We know that the way the law is prescribed under the Nationality Act, the Bahamas government does have some say over whether someone is registered or not, because there's a proviso to the constitutional provision. There are also provisions in the Bahamas Nationality Act which say how you can go ahead and apply, and the Bahamas government can apply those provisions and refuse to register someone in those circumstances. So as much as people want to argue that this is some right which has no caveat, it is not. The government does have some say ultimately over who can be registered as a citizen of the Bahamas. So you can have this argument back and forth. I just want to restate the generality of the position. The Bahamas government follows the law. Where people are not citizens of the Bahamas, they have to get permission to be in the Bahamas or something that shows that they have permission to be in the Bahamas. We're seeking to deal with the number of cases that people have raised with regard to this. And the immigration reform is designed to solve that problem. With regard to any actual statelessness, the Bahamas government recognizes its international obligations and will act in conformity with those international obligations. In fact, the situation arose, Mr. Speaker, with regard to children born to Jamaicans, because the Jamaican Constitution does not give the right at birth to people who are children of Jamaicans born overseas. So the law in our country says once you grant someone citizenship in those circumstances, that they have to renounce Jamaican citizenship. Prior to my coming there, what they would cause people to do is to apply for Jamaican citizenship and then renounce it immediately. That practice no longer obtains. And people can now simply swear an affidavit saying that they have not ever taken Jamaican citizenship and therefore they have no citizenship to renounce. My point is that for every single instance that you can come up with, that's an exception to the general rule. The Bahamas government has moved administratively to deal with those particular incidences. And I do not want anybody to get the impression that there's some wholesale mass gathering up of people and throwing them out of the country. That simply does not obtain. It is not contemplated. It is not probable. It's not, I suppose it's possible, but not with this administration. We are simply trying to reform the immigration laws so that all people who have the right to live and work in the Bahamas and who are Bahamian citizens are within the law. That's it. No more, no less.
Thank you, Honourable Member.